Okay, thank you all. I hope you had a chance to eat well, and if you do need to grab a cup of coffee, feel free to do so, but we thought it would be easier to speak from here, and so to bring you back to hear from our luncheon speaker, who we already heard from this morning, so we're getting a double dose of Angela McKay, and we're very lucky. She, as everybody knows, is a Senior Director of Cybersecurity Policy and Strategy at Microsoft. Her work essentially is to, I suppose, be the bridge between the technical issues and the public policy issues, and so she's been deeply involved in that for many years. I guess you said this morning 10 years with Microsoft. 10 years with Microsoft, so been in the trenches for 10 years now. Works on these issues nationally, but also globally. Microsoft has a global presence, and Angela's work includes across every continent in the world. She also, just to sort of indicate what her connection is between the technical issues and the public policy issues, she's also on the board of counselors for the East-West Institute, which is a think tank that thinks a lot about these things. So she's immersed in this sort of non-governmental policy world, and she also is the point of contact for the National Security Communications Advisory Committee, which advises the President of the United States. So she's also got that more direct policy input. Her was instrumental in the production of Microsoft's white paper, Cybersecurity Framework, which just came out this summer, and that includes some talk about the Digital Geneva Convention and all sorts of other things that we're very interested in here. So, Angela, it's wonderful to have you, and we look forward to hearing from you.
Okay, let's maybe turn this so that you can hear me, but also so I can move just a little bit, because as a speaker, I like to do so. First of all, I just want to start by saying thank you. Thank you to the Center for International Law and Governance. This has been a great conference so far, and we still have more to go. I think that when we were thinking about this conference, we felt like it was really important to bring together a community to talk about how to better protect civilians and civilian infrastructure in cyberspace. And I've been really encouraged and stimulated in my thinking, and I hope you have as well, in this discussion. But also thanks to Fletcher, to Tufts, and really all the speakers and participants. For those of you who don't know me, there's a few number in the crowd who actually do. I, for family reasons, left for a few months to go have a baby and was offline. And so it's been a really nice privilege to come back, both into my job at Microsoft with a bit of a fresh perspective. You don't get a lot of 5 months away from the office. Also, I wasn't sleeping very much, so you could say that some creativity started to percolate in my mind. But it's really nice to be back also in this kind of environment, where we're bringing together different folks from the academic community, from industry, from the applied world, to really talk about this series of challenges. It's a privilege to hear those conversations. Last night, when I got home after dinner, I was just thinking about and reflecting a little bit on some of the things that I heard across the course of the day that really stimulated my mind. And so the three that really came to the top of my mind were a podcast conversation I had with Herb. Herb, where are you at? Did you leave the room? Anyway, there you are. We had a conversation in the morning where we talked about a lot of things, public-private partnerships, et cetera. But I thought what was most salient from that conversation to bring forward was this discussion of trade-offs. What are the different trade-offs that have to be worked through by different players in the community to move forward security and stability? Sometimes, for example, you'll see in the attribution conversation that occurred earlier, national security communities may want to hold on to information because they are thinking about protecting sources and methods. But if you talk to the law enforcement officials in that exact same government, they're like, no, I want that evidence to come out and I want to move it forward for prosecutorial purposes. And there are also other examples of that, but there are this idea of trade-offs, and I'll come to that as kind of a thematic, hopefully, through the speech. I also was thinking a lot about Ambassador Calderon's insightful observations about the challenges for governments with moving forward and the need or the call to action for non-state leaders to become more active in this space. And again, hopefully I'll hit on that in my comments. And then finally, I was thinking about Professor Nye's remarks over or after dinner. You know, he talked about a lot of things that would possibly help restrain government actions in this space, but he also provided a bit of a perspective on the timeline, the arc of events, and compared that with other domains of conflict. And what I felt really interesting about that is he says, you know, we're really still early in this game, right? We're still relatively early, and I want to come back to that point in a minute. So for the actual talk, I thought I'd do a couple of things. First, I'm going to note 4 what I've referred to as inconvenient truths about challenges in improving security and stability in cyberspace on a global basis. The inconvenient truth reference is, in fact, a reference back to the Gore movie. Number 1, I've been engaged, as we've heard earlier, on this topic of security for a really long time. So when I looked at what he had talked about, he said he had given a lot of speeches and then was working to kind of put that into one video. But the other thing that I thought was relevant there is the analogy with the environment and environmental challenges. It is oftentimes very hard with climate change and with cyber operations to really have a good sense or understanding or be able to see the impacts. When you hear about cyber attacks, most of the time people are talking about a vulnerability that was exploited and a number of computers that were affected and what countries those computers sat within. Sometimes you even get an economic number. The window on those are always really huge, so I think there's a lot of subjectivity there. But what you don't always hear about is this kind of the societal impacts and what that really ultimately means. And I think there's some analogies with the environmental challenges. I also think the other thing is it's going to take a multi-stakeholder global community to work through climate change issues. And that is the same premise that I think is going to be necessary for us to work through the challenges we're seeing in international security and stability. And then at the end, I kind of wrap up with a bit of a path forward, looking at what has been done to date, and then hopefully charting out a bit of a vision for the future. So in 4 inconvenient truths. The first one I feel like is in some ways the most obvious one. Digital transformation is creating this huge set of opportunities. We heard Ambassador Calderon talk about this. I also really like the example of the e-lifestyle of the Estonians. And I could sit up here and I'm sure the public sales people would love it if I would go through and talk about each different one of the cool technologies that's bringing things to the world. AI, machine learning, IoT, blockchain, I could. But instead, what I wanted to focus on is not all the digital transformation itself, but what that actually means in application of the technology. The application of the technology is what is bringing economic opportunity and economic growth on a global basis. It is the application of that technology that is helping with social inclusion. It is that opportunity that is lowering the cost for digital opportunities and helping to catalyze a whole set of new innovations and new scenarios for using technology for important things. We talked about Marina's e-lifestyle. I think the guys that are here from Microsoft might laugh. We had a video that we saw as part of kind of the HR requirements for understanding different things at a large multinational. Everybody who's ever worked at one has to do those. But one of the things that I thought was really amazing, we saw a hackback or a video from a conference at Microsoft, internal conference basically called Hack Week. And it was where there was a young gentleman who had lost his arm relatively early in life. And you actually had the ability for the company to build prosthetics at a super, super low cost, so that the child didn't have to worry about ruining his prosthetic. He could actually get new ones because he played in a normal basis. And also because prosthetics actually have to be changed quite often with children because they're growing on such a rapid basis. Those things normally cost a couple of $1,000s a piece. This Hack Week project had it down to something like $7 in 3 days. And so I just want to highlight, as we're talking about rules of the road, we have to think about what we're seeking to protect. It is the benefits of these technology transformations and what it means for society that get us to a place where we're talking about rules of the road. At the same time, technology is omni-use. Omni-use is a phrase I've actually coined many times. I know dual use is very familiar in the community. What I talk about here, though, is it's not just commercial or military application of these technologies. It's commercial, military, social application of these technologies, and every single thing can be used, abused, or misused to create harm. I don't think it's a one-to-one ratio, thankfully. I actually like to think that the opportunity side is much bigger than the risk, but it's non-linear, right? And you can't say it's one-to-one, and I don't think you can say it's a similar relationship across all the technology domains. I think what comes out of this whole kind of construct is the benefits we're reaping from digital transformation, the societal benefits, are at risk, and we have to think about how to protect it. But the good news is there's actually been a lot of work in this space. That's what led us, that premise has led us to the creation of rules. And then we're going to get to the second kind of inconvenient truth. The second inconvenient truth is there has been a lot of progress on different norms and bodies to help advance international security and stability. But there's a lot more to do. The threat is also getting much more concerning. So on the rulemaking side, I will not spend a huge amount of time going through this, but you could from many papers out there, go with, there are UNGGE rules. There's the Shanghai Cooperation Organization, OSCE has it set. G7 confirms some, G20 confirms some. The Italian Manual 1 and 2 also have a discussion of rules and application. And so there's a lot out there, and I want to make sure I highlight this really, really clearly. This is an important foundation for where we need to go. There need to be some rules of the road for such that when there are violations, it's a violation to something. I'm very pleased to say that Microsoft and myself actually helped, I think, contribute to some of that body of work. We've come out with lots of papers, we put proposals out, and I've actually had very good feedback from governments that whether or not they agreed with each component of the things we've put out, it helped catalyze thinking in a conversation in their governments about the right things to do. And so I'm really, really proud of that. But ultimately, the threat landscape is really actually just growing dramatically faster relative to the progress we've made. So a couple of different statistics in that space. First is the increasing number of attackers. When I started talking about cyber norms, I think it was about 7 years ago, I was working with the team to find it out. We had this stat, and I think it was like 20 or so governments who had stated doctrine on offensive operations. So let's say that was 7 years ago. And I remember on the slide, because we used it for several years, we kept having to change that number. And then it was 32 one year, and now I think the number is 46. And that's where you see stated doctrine in that space. That doesn't necessarily account for governments who don't have stated doctrine. Now let me be clear, doctrine is generally a good thing. We're yay doctrine, yay transparency about it. But what it shows is this increasing number of state actors. And then that ties really to the next kind of point, which is there's also a greater proliferation of capabilities and tools between different types of sophisticated actors and outside of the sophisticated actor pool. I think Eternal Blue is probably one of the classic examples there of a very sophisticated actor having something that is difficult to operationalize and then another actor being able to operationalize that. Furthermore, we also have this increasing number of attacks. And I have almost a sobering statistic from inside of our, let's see if I'm going to get the name right, Microsoft Threat Integration Center, something like this, maybe Mystic. It sounds really cool. But think about the team inside of the company who is working on the harder, sophisticated actor problem set. This is what they work on. This is what they track. their data is there has been an 8-fold increase in the last 3 years of sophisticated actions in cyberspace. And I think I want to break that down because sometimes you hear things in the news and you get things that have named reports, but there are also really almost 2 ways of thinking about that 8-fold increase in 3 years. The first is the thing that you hear about in the news, the big named events that I think have a recognizable societal impact. And you could go out and name, like, I'm not going to name all of them here because it would take a little while, but you could say WannaCry, NotPetya, Saudi Aramco, the Estonian attacks, Sony, the Japanese pension fund, OMB, I mean, like, whichever number you want. But I think what's really important there is there has been an increasing type of consequences in those particular attacks, and they have direct societal impact. Whether you want to talk about Ukraine basically being almost as a country taken fully offline, that's significant. Whether you want to talk about Maersk, one of the largest transportation companies in the world, again, taken offline. I happen to be in Copenhagen, supposed to meet with the CSO of Maersk that day. So if you read the Wired article that Joe referenced last night, and I will reference again later, and if you haven't, you should, you walk into the lobby of Maersk, and it is, I think I said to someone, it was just quiet chaos. The receptionist didn't know what to do. They couldn't call people when you showed up in the lobby. They didn't know how to get through the security gates. It was really, really quite concerning. And then when you go into the WannaCry attacks and you see, I think it's something like 19,000 hospital appointments. You might think a doctor's appointment's not that important. But what if you're the person who's going in to hear about what the results from a particular screen for cancer might be? You probably didn't want that appointment delayed. So that's just a few of the things that are in the big, newsworthy societal impact category. But something that you get to see when you're a vendor of the size and scale of the company I work for, and there are only a handful probably of companies like this on a global basis, is we actually get to see the less visible but truly insidious acts of sophisticated actors that don't come out in the news and media reporting. This is the actors that are sophisticated, that are persistent, and because the tradecraft is sufficiently good, it doesn't end up promulgating necessarily in the same way as all the ones that get the information I talked about at the top, the newsworthiness. But the impacts to society could be as great, you just don't know about it, right? When you're getting a theft of a particular information from a military source in one country and given to another, that actually does have a societal impact. You're just not seeing it. It's not a first-order impact. It could be a second-order impact. And one of the things I think in terms of us being able to see more of that is not only is Microsoft and our enterprise the regular targets of sophisticated actors, but as we have started moving in, as we operate a significant cloud infrastructure on a global basis, and we're operating the cloud and protecting customers in that cloud, the adversaries have followed the customers. And so the aperture of visibility for us has gone up even more. Adversaries follow their targets into the cloud, so we see more. So ultimately, in this space of the inconvenient truth, we've done a lot. There's more that needs to be done. The work we've done is necessary, but it is ultimately insufficient. So in the third area of an inconvenient truth is no one can do it alone. This would actually be so much easier if governments could go out and get it all figured out. I promise you the technology industry, if we could get it figured out, we'd just be like, yes. Civil society and academia as well. No one really can do it alone. And I want to break that down just a little bit because people say that, but I don't think they always explain why. In that space, I think, from a governmental point of view, I really liked several of the points that Marina brought up. She talked about cooperation has reached an impasse. I, by the way, wrote down a lot of her points because on this section, I feel like she was outlining exactly what I wanted to say, which was awesome. So cooperation has reached an impasse. And whether it is ideological differences that are causing that impasse or political will that is impeding progress, it's not moving forward. She also said states are not interpreting the norms that exist. In other words, they're not bringing them into an applied context in their environment. And that's really what I'd like to make sure we highlight as another one of these kind of inconvenient truths is, while the rules are out there and they exist, they are not being applied in an operational context. And this I want to reference back to that Wired article. When there are these major events that are occurring, when Maersk is basically taken offline, there is no reference that says, hey, was this consistent or inconsistent with the norm that came out of the GGE on critical infrastructures and that being off target? Was that okay or not? It's not getting referenced in the diction of, are these attacks consistent or inconsistent with international law? Aramco, same example. That may occur in some ways in small pockets of the academic world. It may also occur in small parts of the diplomatic world, but it's not occurring in a sufficiently public conversation that it can function as a sufficient kind of deterrent in this environment. So if you have states not interpreting laws, the rules not being referenced, I also think you have efforts that are intended to impose cost. Efforts like putting forward an attribution group and thinking about what are the costs. The characterization I would have is that really the efforts have been mixed at best. And that, by the way, is not me making a judgment call. It's not like it's bad. It's just hard. We talked earlier about in-domain response could be very escalatory and could actually cause more instability. Sometimes imposition of cost in a cross-domain way can be something where maybe a government wants to do something and their industry goes, whoa, whoa, hold on, be careful, don't do that. That could cause a bunch of economic impacts. Or because of the connectedness of the economy in general, maybe you have a set of countries who want to impose sanctions and another set of countries who say, whoa, whoa, that would actually be too hard for my economy or some of my services to deal with. You see that in some ways play out in the non-cyber world with regard to the US, Russia, and Germany in terms of really balancing what those equities are. So I think what that nets out on the government side ultimately is the roles of government as users of technology, protectors of technology, and exploiters of technology has complicated what they can do in this space. There are trade-offs between each one of those roles as you think about it, and I think in many cases, parts of government haven't figured out how to talk with each other to make those trade-offs, particularly when you get into bigger ones. Also hard in the smaller ones as well. But the other thing is, and that's kind of the users and roles, is are they unable to get forward with interpreting an application because it's hard? I also believe there is at least a non-trivial set of governments who would like rules to exist, but don't necessarily want a lot of application, interpretation, or accountability to them because there's a desire to preserve strategic ambiguity. Governments don't want to carry out operations that are going to break into actual international law. That space is a lot more clear. They want to stay below that and kind of throw these punches to test what the bounds of that environment are. They haven't figured it out yet, and they're not willing to take these things off the table. I did not get to attend an event that was out in the UK last week, but apparently at this event there was a discussion among some senior diplomatic advisors that actually said, not only is it not in my adversary's government to take things off the table, it is also not in the interest of my government to yet take things off the table. Interesting, right? That's admitting something that I don't know you would always get someone to admit. So just to be clear, I'm not going to just beat up on governments. I'm actually going to come in with an inconvenient truth underneath this, no one can do it alone, for industry. So for industry, we are creators, operators, users, protectors of technology. but we also have significant commercial interest in this space that is part of our fiduciary responsibilities. And so when attacks occur, y'all might, or there's a community who might think about it as attacker 1 hit target 2. For me, in most cases, that is customer 1 targeting customer 2. Except for the few places in the world we're not allowed to sell our products and services. So, but the bottom line is industry has a complicated series of equities as well, and how to work through the trade-offs that balance these approaches and equities gets into you really cannot do it alone, neither entity. So the fourth inconvenient truth. So we are at the early stages of development of kind of a set of rules and accountability for international security and stability, but it needs to move much faster. And I think, I don't know if Professor Nye is here today. What I would say is, I do not dispute in any way, shape, or form this idea that we're at the early stages. But what I would say is, let's look, and he looked at it in a relative context, relative to nuclear, relative to chem bio, and another word that just ran out of my head. But I think what is important there is the cyber domain, or at least the tools, technologies, and practices underneath that, are moving at such a more rapid pace than that particular challenge did itself. So we have the pace of innovation that is challenging that, the speed at which something can propagate around the global domain, the potential for miscalculation, whether that miscalculation is on carrying out an attack and like, whoopsies, that wasn't quite as strong in the tradecraft and started moving around indiscriminately around the world. Or miscalculation in response when a particular targeted country or government doesn't necessarily understand the intent of a piece of malware, because it takes time to reverse engineer it, but it's in such a critical part of their critical infrastructures, they feel an urgency to respond. What that ultimately creates is a potential for very rapid impacts, potentially on a global scale. I don't think that's how cyber attacks are going to go, but the potential for accidentally tripping into that totally and completely exists, particularly when you juxtapose this with what I said earlier. There are a whole new set of actors in this space. They may not have the same doctrine, they may not have the same limits on their capabilities, and they may not operate with the same level of tradecraft. Oopsies could actually really happen in this environment. The other thing maybe is just an example that substantiates that is the 2016 DARPA Cyber Grand Challenge, which I'm sure most folks in the room have heard about. This was basically machine-on-machine, defender and attacker. And Duncan always likes me to have me say asymmetric polymorphic code, because it's something that I think about. When we're talking about the cyber domain, we're moving past human defenders and human attackers into computer attackers and computer defenders operating on machine speed. And so when you think about that and the comment of we're at an early stage in the cycle, can be early, got to do more faster. So then a couple of just thoughts, and I'll look really fast and see how I'm doing on time. Oh, I've gone longer than I intended. On a path forward. So Microsoft has spoken, and I think it's been said numerous times, we've been speaking on this series of issues and a wide variety of issues for many, many years. I started out doing the norms work just about 7 years ago. In 2017, we made a call for a digital Geneva Convention. That got a lot more people talking about international security and stability in cyberspace, so big upside because it got it outside of some niche communities. Downside is it was misinterpreted by some people for their particular goals. And so we've taken that in and we work to learn from that feedback. When we look forward, not just from a Microsoft point of view, but things we're working to catalyze in the ecosystem with others in industry, with others in the academic world, with civil society and with governments, we're going to be talking more about the concepts of digital peace. Now let me be very clear, I know that digital peace is not going to be how the overall ecosystem operates, it's not going to be a kumbaya land, but how can you work to advance the ideal the ideals that we want to protect. We're also going to be talking a lot more and seeking to drive greater multi-stakeholder engagement on these issues. Multi-stakeholderism is the right thing. Marina also mentioned this yesterday. But just to be really blunt, for those who have not gone into a large multi-stakeholder format at any point in time, it is painful and it is slow. And so I think we're going to have to really work on the models that allow for sufficient inclusivity of diverse expertise and representation, but also agility to deal with the particular problem space. As part of that, I think we also have to get the public more involved. You know, we talked, again, Marina talked about political will. One of the ways to think about creating impetus for action is in terms of getting the public involved. And when I think about many of the folks in this room, people who are more in the digital native space, I think that they feel like this is an environment in which they operate, and it is at risk of these particular governmental actions. I also think we're going to need to strengthen the existing rules. I talked about rules are important, rules are not being referenced. How can we get more governments and more in the multi-stakeholder community to say these are the right rules, and I'm going to either make politically binding or even more firm binding commitments to them. We also need to work more on organizational models that really start to fill the gaps in the multi-stakeholder community. How can you reinforce norms? How can you support accountability? And how can you help victims of cyber attacks that don't have the same resources available to probably most organizations sitting in this room? There is a significant digital gap, not only in the digital divide, but also in access and resource to security expertise on a global basis. And we're thinking a lot about that. Last but certainly not least, for those who had heard about it, the Tech Accord is a grouping of industry. I think we started out at 34, we might be close to 60 now, companies who are making commitments ourselves about how to support security and stability in this space. Has 4 common pieces: do defense, don't do offense, collaborate with each other, and enable others. But I think that was really meaningful because as opposed to being any particular one actor in industry, it's industry coming together in this space. As we look forward, the last thing I'd just like to say, because I think sometimes when you sit in a room like this, you can think a lot about what's on paper, and those accomplishments are really, really important. But I think what I'd challenge us all to do is think about how do these activities accrue to changes in behavior. Rules are important. Rules that aren't being followed are not necessarily as useful as I would like them to be. I think what we're wanting to do is shift the behavior in that environment, and I think we have really great opportunities to do so. And from a Microsoft perspective, I could say we're really excited to both help sponsor this conference and engage in a lot of places. The Global Commission, some of the Talon work here, there, and yonder to help catalyze this. We don't think our way is necessarily the best way, but when I said more needs to be done and it needs to happen faster, we're trying to promote that and promote others to join in that with us. Thank you so much.
Thank you very much for those thoughtful remarks, both reflecting on what we heard yesterday and this morning, and also previewing what we're going to be discussing this afternoon, because we're moving on to compliance, but it turns out the compliance paper isn't only about compliance. And then we're going to talk about international organizations, which are either venues for or perhaps one of these multi-stakeholders. So thank you so much for helping us think through some of these issues and explaining a little bit Microsoft's position. So thank you both for financial support for this, but also the intellectual support you provided. We're going to move straight into the next panel now, so I could ask the panelists to come up and everybody else not move too far, too fast.
my great pleasure to moderate what I call the chicken and egg panel. And it's a chicken and egg panel because the issue is compliance, but the question, as Angela raised so beautifully in her speech, is what kind of norms are we talking about complying with? And, or does certain behavior help create, I mean, both good behavior and bad behavior, create the norms that demand compliance? So, to address these questions, let me start with Martha Finnemore, of whom I've been a great admirer for many years, who's the university professor of political science and international affairs at the Elliott School at George Washington, and who won the Woodrow Wilson Award for the best book in government, politics and international affairs in 2004, who keeps on writing. And her latest with Oxford is Back to Basics, State Power in a Contemporary World. So that's only one of her many distinguished publications. Duncan Hollis, who is Associate Dean and Professor of Law at Temple Law School, who has been a non-resident scholar at the Carnegie Endowment, which is a very prestigious appointment, who is a Fletcher graduate, I'm glad to say, and also a prolific author. And then our own Ian Johnstone, who is my colleague, who is now serving as interim dean of Fletcher and was our academic dean. And before Fletcher, he had served in the UN Executive Office of the Secretary General, and he has written widely about international law and particularly about the UN, and most recently the Oxford Handbook on International Organizations, to which I have referred with great gratitude in my own teaching. So let me start with you.
Actually, we're starting with Duncan.
Okay.
Great. If that's all right. Well, thank you. I want to add my voice to those who've already thanked Joel and Ian in the center for organizing this great event. It's a real pleasure to be back home, so to speak, at Fletcher. It's been a few years, and it's great to be back. I should also disclose up front, especially after Angela has just spoken, that I wear a lot of hats, and one of my hats is working with Microsoft. One of my other hats is as an academic, and I should be clear that I am wearing the academic hat in what I'm going to be talking about. It used to be, when you went to cybersecurity conferences, particularly cybersecurity conferences on international law, they devolved into guessing games, right? Who hacked Sony Pictures? Who perpetrated WannaCry? Who stole $81 billion from the Bank of Bangladesh? Last week, though, we got some answers, right? We have a much publicized Department of Justice indictment implying or holding that North Korea was responsible for all three of those cyber operations. What's more, the Department of Justice tied them all to a specific individual, one Park Jin-hyuk, a North Korean who operated out of a commercial firm that was said to be a front for the North Korean government. And I think the charge is noteworthy because now we can add North Korea or a North Korean name to a roster that keeps to be growing of Russian, Iranian, and Chinese hackers, all charged under U.S. law for engaging in malicious cyber operations. Now, Mr. Hyuk is not in U.S. custody. He's still in North Korea, and let's be frank, the likelihood of him coming into U.S. custody and actually being fully prosecuted is quite unlikely. And I think the same actually can be said for the vast majority of those others who've been indicted in operations that are alleged to be state-led or state-sponsored cyber operations. Which begs the question, what's the point of these charges? You know, indeed, what's the point of, I think one of the earlier speakers today said we've got like more than now 20 cyber operations that have been associated either with the state directly or that are some way sufficiently state-sponsored that people would say a state was responsible for that. For many, including, I'd say, the Trump administration, the idea is that if you can't directly enforce the rules, let's do naming and shaming. Let's name these folks publicly, name the state publicly, and then hopefully they'll be somehow shamed into becoming more compliant in their behavior with what the accuser wants. Great idea, but there's a catch. So far, we've had pretty scant evidence that these efforts, what social scientists call naming and shaming, have had real effects. States who are accused tend to deny the accusation or challenge it in some way, and the evidence seems to suggest in most cases they continue to engage in the very behavior that led to the naming and shaming in the first place. So we have a first puzzle here, which is what's the point of naming and shaming if it's not going to generate more compliance? And for those of us like myself that are international lawyers, I think there's a second puzzle, which is that in these 20-something cases of state-sponsored cyber operations, there's a silence of international law. Whether it's Stuxnet, OPM, WannaCry, NotPetya, there's a pattern. The accusers say little about what's wrong with the conduct they're exposing, and if they do, they're pretty generic. This was bad, this was malicious. Maybe they'll even go so far as to say this violates international norms without specifying what those norms are. As Angela just said in her keynote, what we don't see is anyone invoking whether or not the behavior was compliant with specific rules of international law, like sovereignty or non-intervention. In fact, they don't mention international law at all. And so it's these two puzzles Marty and I wanted to examine in our paper. You know, what can we expect from all this naming and shaming, and where's the international law? And I'll just preview a little before I let Marty kind of take us forward. We began by actually, and we think we agree on this, finding naming and shaming is an inadequate concept. We think it's a useful concept, but I think it doesn't capture the full breadth and range of things that we would label accusations. We think accusations is maybe a better concept to be working with. And our paper's focused on unpacking what do we mean by an accusation. And what we find is accusations can serve multiple functions. Maybe compliance is one of them, but it's not the only function. And indeed, it also can be a constitutive function, that accusations can lead to an interchange where the rest of the community that's observing the set of interactions may decide, oh yeah, we actually agree what you're complaining about should be a rule, and that the rule itself can be clarified or formed through the accusation or the provocation of an accusation. What's more, we think accusations can be, and are in some cases, conducted strategically, right? That they can be formulated differently depending on what function the accuser wants the accusation to serve. And of course, beyond their functions and contents, we think external conditions matter, that you have to look at the world in which you're trying to use the accusation, and that certain conditions may lend themselves to compliance, where accusations might lead to compliant behavior by the accused, but other conditions might lead to the constitution of new rules, and that those conditions won't necessarily overlap entirely, that you have to be aware of what the external conditions are. So we try and elaborate these at the end of our paper by taking the functions of accusations, the contents of accusations, and the external conditions, and ask us what they tell about the international law story to date. Why has international law been so absent from accusations, and how might accusations be better constructed to improve compliance with existing international law or lead to the clarification and development of international law prohibitions or permissions in this space. So let me turn it over a little bit to Marty. I think you're going to hopefully explain how you and I got to avoiding naming and shaming as a label, and talk a bit about the other functions we see accusations perform, and then I'll come back and talk about contents and conditions.
So again, can you hear me? Are we good? All right. Having not been able to hear people, it's one of the more frustrating things. As Duncan pointed out, when Ian was setting up these panels, the plan was that there was going to be a law person and a technical person. Not so much. I'm the technical person, and anybody who knows me will tell you that, you are a very kind person for putting up with this kind of technical help. But we are interdisciplinary. I'm a political scientist by training, and this phenomenon that set up this first puzzle, where you get states making these public accusations, is long-standing. Political scientists in IR have been studying this for a long time. And it goes under this concept, naming and shaming, spoken all in one breath, as if shaming automatically follows from naming. And we didn't have to think about this for a very long time before we figured out empirically this is simply not true. Whether shame follows from name is an open question, and as scholars we wanted to unpack that a little bit. But this has got big legs in big parts of social science. Naming and shaming has a big literature. Human rights scholars are all over this. This is a major tool for civil society groups, but also for governments to try to promote compliance with known and well-articulated norms and rules, treaty rules in human rights. It's used by environmental groups. And the basic logic of the naming and shaming model is pretty straightforward, right? You've got a bad actor. Bad actors want to hide their bad actions. So states that torture would really prefer you didn't know a whole lot of the details about where the bodies are buried. Companies that pollute would really rather you didn't look behind the curtain and find out what's going on with that. Financial actors that engage in sketchy practices would really rather you didn't look too hard into that. So the idea is if you can name, publicly call out these people, that will have reputational effects at a minimum, which might affect their bottom line and other things that are useful. And there's also a discourse about whether there's some kind of internalized effect, like Joe was talking about last night, that you actually get some kind of contrition and shame that comes out of this. But at a minimum, you might expect some kind of reputational damage that would promote compliance. You knew we were going to get to that. We're not seeing it, not in cyberspace. We're seeing a lot of naming, not so much with the shame. So what's going on here? And our hunch is that there's a lot more going on than the basic model captures. We started using this term accusation to try to unpack a much broader bucket of things. And we have 5 functions that we identify in the paper that this kind of naming, this calling out, this accusing might serve, and might serve, as Duncan said, very strategically. States think hard about who they accuse, how they accuse, what's in the accusation. So the 5 functions that we see going on, and there may be more, we'll be happy to take amendments. One is compliance. I mean, it might be that you actually get lucky and the basic model works. If this is true, it's most likely to happen, we would guess, among like-minded countries. So in Marina's world, norms are always for the good guys, right? I mean, in the sense that the rogue actors are not going to buy into your norms. But among the like-mindeds, who actually have some degree of agreement about what the right thing to do is, naming and shaming, they might actually produce behavior change. Those people care about their reputations. They care about being part of this group, being states in good standing. So you might get some change there, but I wouldn't put all my eggs in that basket. And we wanted to explore this further. So we got at least 4 more. One other function these accusations might serve is for defense. Public accusations of bad activity convey critical information to third parties beyond the accused and accuser. They often, first of all, they tell the third parties that this problem's going on out there, beware, be alert. But often these accusations are couched and framed with specific information about indicators of compromise, about what's the details of the malicious malware and the nature of the attack. I mean, this happened in the Russian election attacks, for example. So there's a third-party knock-on effect that might be positive simply from making these accusations. A third function that might be served is deterrence of future perpetrators. Public accusations do more than tell the accused, you're caught. They also might deter others from engaging in this kind of behavior in the future. If you think you can get away with it and have no one know, not so much. We're watching. Fourth, public accusations help coordinate punishment. I mean, even if you're not ashamed, even if you're not worried about your reputation, if you want to coordinate sanctions, the public statements of accusations, particularly when third parties will line up behind those same statements, that's how you start to coordinate group resistance and response to bad behavior. But the fourth piece of this that much more of the paper is about is what Duncan hinted at. This public accusation helps constitute new rules, new norms, new understandings, and potentially new kinds of law. That an accusation sends a clear message about what the accuser thinks good behavior looks like. It usually is accompanied with an argument and evidence about why this preferred rule, this preferred behavior is the right one that we should all line up behind and rally around. I mean, going back to Marina's remarks, you know, since 2007 Estonia attacks, you know, at that time a lot of this behavior was new. But we've seen a lot of back and forth now with more and more attacks, more and more responses, and it's through these public claims about what the rules are, who crossed the line, why the rules should be what the rules are, why that's the valuable rule to defend. That back and forth in the political world and in the legal world, that accusation response helps flesh out where states think the boundaries are and helps line up support behind rules. And again, states think strategically about how they respond to these accusations. They can deny outright both the act and the claim that the rule is a good rule to begin with. So not only did I not do it, but even if I did, what's wrong with that? That's one kind of response. Another kind of response is denial of the act, but not the rule. I didn't do it. Yeah, I know that's the right rule, but no, I didn't do it. That's a different kind of engagement that tacitly says, no, the rule is the right rule. It's an empirical, you know, now this is an evidentiary, did I do it or not what's the rule. Or you could have silence. And this also goes back to something that Angela was saying. Silence is actually action, right? It's not nothing. Silence matters in this law space because failure to object is tacit acquiescence in the construction of these rules. If we sit on our hands, those rules are going to roll out and become normalized, whether we like them or not. So states and the people in them need to think strategically about how we respond in this space.
Yeah, so keeping an eye on time, I'll try and just move through. So given that we have these kind of at least 5 functions, one of the other things we wanted to think about was if we don't think naming and shaming or accusations can be said in a single breath, what are the component parts? And instead of 2, naming and shaming, we actually kind of came up with accusations have 3 elements. One is the attribution, which we were talking about before lunch, right? The process of associating what happened with a particular author or territory. But we think, second, there's exposure. There's that question of the process of disclosing what happened to third parties. And third is condemnation, right? The process of signaling disapproval with what happened. Now, accusations can do all 3. Look at the U.S. charges of Russian responsibility for the election interference in 2016. But, and we think this is important, we don't think accusations have to always do all 3 things, right? So, for example, you can have attribution and condemnation without exposure. And indeed, we now know that President Obama, his first course was to go to Putin and personally tell Putin, I accuse you of doing this election interference, and it did it in private. So you had an attribution and you had condemnation, but you didn't have exposure. Alternatively, you can have exposure and condemnation without attribution. So anybody who follows the Triton Trisis malware, you see people exposing this malware, condemning it because of the threat it poses, because it interferes with safety equipment in industrial systems, opposing it, even though nobody will publicly, or at least is not publicly, no state is publicly accused another state of being responsible. So you can actually, have 2 of the 3 in that sense. And our point then is that attribution, exposure, and condemnation can kind of be mixed and matched to kind of pair with whatever function or functions the accuser is seeking to achieve, right? So if you want shaming, right, compliance from the accused, you're going to need to have attribution. You're going to need to point that finger in some way. Otherwise, it's hard for the accused to know they've been accused. But I think attribution is less important, if the goal is defense, or even if it's the constitution of new norms. If you're trying to create a new norm, you're trying to convince the community, those third parties, that this is the behavior that we should all expect. And you may be happy to have the accused along for the ride, but you don't necessarily need that one voice to join if everybody else is on board. In trying to figure it out, though, we also think that one of the things is recognize that each of these elements, the attribution, the exposure, the condemnation, has its own kind of moving parts. So attribution, as I think we've already kind of discussed, can vary in terms of its specificity. So Herb Lynn, I'll cite his article twice now today, we'll get it cited, right? He did a paper where he said, look, you can attribute to the specific individual, think Mr. Hyuk, you can attribute to the state as a whole without actually saying individually who did it, or you attribute technically to a machine or an IP address, right? So you have a choice of how specific you want your attribution to be. Exposure, similarly, you can do it directly, or maybe you have somebody else, you have a proxy do the exposure for you. You can also do it just a straight up j'accuse, no evidence, or a la Mandiant or Citizen Lab, offer a lot of technical data to back up your accusation. So in other words, there's kind of a question of how much documentation to employ in support of your accusation. And I think in a paper such as this, we're basically saying more research would be needed and developed to figure out whether attribution should be more or less specific, how much documentation is needed. So like, we're not sure, for example, that more attribution is always going to be productive, that there's actually a real risk that if you throw so much specificity and documentation at a state, you might actually risk stigmatization, where that state says, I'm taking my tools and I'm not going to be part of this community anymore, I'm going to distance myself from this community. Whereas if you're less specific in your attribution, say follow a due diligence model where we don't know who in your territory was doing this, but somebody was, what are you going to do about it? It gives the state an ability to react without having to admit complicity or fault. Similarly, for compliance purposes, we're not sure how specific the condemnation has to be. I mean, sure, you could condemn the accused for doing something that is a violation of the rule of sovereignty as expressed in Article 4 of the Tallinn 2.0 manual, right? And maybe that'll help move it along, right? But you don't have to do that. You could just say it's bad and the actors could respond. I do think it's a little harder to constitute new norms or practices without such precision, right? If you're interested in customary international law, it has two elements, state practice and this opinio juris, the idea that something's being done out of a sense of legal obligation. So we have to find some evidence of what states think the legal obligation is. But you could have some legal constitutive value in condemnations, even if you do say nothing about international law. And this goes to Marty's point, right? That silence matters, and if states say silent, over time, we might reason that the behavior that states have stayed silent about is permitted. What international law doesn't prohibit, it permits. And so if states don't object to the WannaCries and the NotPetya's, maybe that signals that internationally it's legal, it's lawful. So there is a value to these accusations, even if they say nothing about international law, for at least signaling dissension, that there's not acquiescence. And so in that sense, they can be constitutive, even if they don't name a specific norm or rule. I see I'm looking at the time, but I want to flag that it's not just about taking the composition of an accusation and pairing it with the functions. You have to look at the external conditions as well. We kind of in our paper highlight three: the relationship between the accused and the accuser, the relationship between the accused and the third-party international community of states, and the relationship between the accuser and that third-party community of states. And when it comes to compliance, we think the first two matter a lot more, right? What kind of reputation, what kind of leverage exists in between the accused and the accuser that might lead to compliance? And or how does the accused value its relationship with the community in which the norm or customary international law rule has been invoked and situated? On the other hand, when we're talking about constituting new rules, we actually think it flips, and it's the relationship between the accuser and the community that becomes much more important, right? And so in that sense, we're going to want to know how much, credibility does the accuser have with the community? What's its track record? What's its history? And that may tell you a lot about its ability to achieve success when it's proposing and saying, hey, shouldn't we all agree that Trisis and Triton, whoever did it, should be a violation of international law? And as to all of, that international law question, we kind of close the paper by basically trying to say, well, why have we seen silence so far? And we think there's a couple of explanations. One is that states might not think this stuff is unlawful, and some of it might not be. The OPM hack was espionage on a really big scale, but it was espionage. So maybe states don't want to put international law in their accusation because they don't think it's unlawful. Or maybe they know it's so contested, the legal question, they just don't want to use the accusation to trigger that fight in the specific case. They'd rather fight the fight elsewhere, so they just avoid that language of law. It could, as Angela and I think Marina said, it could be about reciprocity. States want the room to maneuver. Iran might not have said Stuxnet was violation of international law because it wanted to engage as soon as it could reverse engineer Stuxnet in similar behavior and do tit for tat rather than use the tools of international law in response. And I think fourth, frankly, and this goes to some of the stuff Michael and Nicholas were talking about, documentation is a big issue here. You know, to get an accusation under international law is going to require more evidence and different types of evidence that may be hard to acquire, and even if you have acquired it, there may be other reasons not to put it forward publicly, which then might lead you to pull back from using international legal discourse. That said, we think there are some ways states could improve compliance with respect to international law accusations. One, they could reference international law in their condemnations. They could do more private accusations. They may actually work a little better if you get, you know, offline kind of conversations where two states sit down and say, we think you did this and we think it's a violation of this rule of international law, may actually generate some more productive results. We also think you might think about accusations that step back from the accusations in terms of prescriptions and prohibitions. We think what you're doing violates our sovereignty or our, you know, you're intervening in our affairs, and flip it into due diligence, right? Say, hey, we think you're not doing enough as a state to police your own territory and exercise your own sovereign rights and responsibilities, so you could do more, and that might actually have some more results. At the same time, we think, and I'll start to close here, that accusations could be focused on the constitution of rules, in which case you might do different things. For example, if you care about the credibility of the accuser, maybe we want more accusers. Maybe we want more incidents like NotPetya, where you have not one, not two, not seven, but 9 states pointing the finger, right? That might be a better tool to get the rule constituted if you already have a really big group of states saying, yeah, we agree. Or maybe, and this goes to where we were discussing the last section, maybe you try for a credible third-party institution. It doesn't have to be state organized. It could be an NGO or something like that that could do some sort of these kind of involvement in accusations, whether it's the forensic work or more. So just to close out, 3 takeaways that we at least were hoping the paper would convey. 1, accusations can do more than name and shame. 2, accusations may achieve multiple functions, so compliance, yes, but also defense, deterrence, punishment, and constitution, and that you have a menu and a toolkit in the accusation itself that can be used strategically to try and achieve those functions. And third, accusations are relevant to international law, whether or not the accusation uses the language of international law, and we think there might be better ways to construct accusations if you're interested in either international law compliance and improving it, or you're interested in clarifying or identifying new rules of international law, particularly custom. So a lot to unpack there. Thanks for letting us run a little over. Sorry.
There is a lot to unpack there, and I'm going to try to help to do it in 10 minutes. First of all, Marty and Duncan pulled a little bit of a sleight of hand here, because we asked them to write a paper on compliance, and they wrote a paper that's as much about the creation of new law or constitution of new rules than it is about compliance. But I fully understand why they did that, and I agree that that's actually the right way to think about this, and I suspect Tony Chase does as well, because the line between interpreting the law, applying the law, and creating new law is blurry. It's blurry at the domestic level, and it's even blurrier at the international level. And I think any move or claim is probably going to do a little both. And secondly, in relation to one of the issues that came up in the earlier panel, is a lot of this doesn't get settled in courts. Most of the time it's not going to be discussed, settled in courts. There's not going to be an authoritative determination of this is the law, and therefore this is what we need to measure behavior against. It's going to be a much more diffuse process in diplomatic conversations, in political bodies, and in the back and forth between states. So for that reason, I think the sort of looking at the relationship between compliance and the constitution of new rules is a good idea. I do, just from the point of view of compliance though, one request I guess I would make is that you do spend a little bit more time identifying and assessing the extent to which there are rules. You know, you do legal rules, legal norms. You talk about the Talon Manual and you make a reference towards the end at the sovereignty principle, and you allude to the question, is this sovereignty, is this a principle or a rule? But if you look down the list of other norms identified in the Tallinn Manual, like non-interference, short of the use of force, which is clearly a violation of Article 2.4 of the UN Charter, but short of the use of force, what does the non-interference principle mean? Is that a rule? Is it a principle? Or due diligence, is that something that's been specified enough that you can make legal claims about it? And I don't think in your paper you need to come to conclusions about any of that, but at least highlight what some of the debates are and the level of uncertainty and the degree of consensus that may or may not exist around some of these so-called primary norms, that the rule that, the term that Joel introduced at the beginning. And then just one other legal concept here is the Lotus Principle. If it's not, according to the Lotus Principle, if it's not prohibited, it's permitted. How does that play into this area of trying to develop new norms or assess compliance against norms? Second point, you have a lot of, you have these three lists. You've got 5 purposes, 3 processes. You actually had 4 conditions in the paper. You've reduced it to 3. And you're trying to describe the relationship between all of these things. And it would be nice if you could create some 3-dimensional image that does that visually. I think it's impossible, but I think at a minimum, and where you really focus, is the relationship between the 5 functions and the 3 processes. And if you could put those in some tabular form, it would be helpful. Which processes serve which functions, or which purposes are best advanced through which processes. But even then, I think if you try to do that, you'll discover it's not as clear as your assumptions or conclusions seem to suggest. It's more speculative. You say, well, maybe you don't need attribution, but you do need this. And a couple of things that jumped out at me is, one question is, is attribution necessary to have constitutive effects? You left that open in the paper. You just said you thought it probably is, so I would specify that in what you're doing. Another one is exposure or publicity. Is that necessary for defense or deterrence? You say yes, but I'm not sure that's entirely true. You could quietly tell your allies, you better watch out because so-and-so is able to do this, so build up your defenses. Or you could quietly go to the potential attacker and say, by the way, we know you did it last time, so don't do it again because we're going to be able to retaliate. And that would have the deterrent effect, it would have the defensive effect, and it wouldn't have to be public. Okay? And then the third one that jumps out at me is whether condemnation is necessary to have this constitutive effect. At one part in the paper, you seem to say yes. In another part of the paper, you seem to question that. And your example of Stuxnet is interesting because what you say is that, in fact, a lot of the claims or the statements made about Stuxnet were claims of approval. It was, we approve of this. It's not that we condemn this or disapprove of this. I think that's probably right and interesting, but I wouldn't call that an accusation. I mean, when you pat somebody on the back and say, good job, that's not an accusation. It may be important to know whether approvals can have constitutive effects, but I'm not sure it's right to call those accusations. Another point, you asked the question, why do states not invoke international law when they're leveling accusations? Often they don't. Usually they don't. Why not? Your answer is, well, maybe it's because the law is uncertain. They don't expect much to gain by leveling an accusation on the basis of law. Another possibility is they actually don't want to have this constitutive effect. Okay? They literally do not want norms to develop in this way. If you start leveling accusations on the basis of soft law, let's say, and then it starts to harden, well, the more powerful states, as we talked about earlier, may well not want that to happen, and so they're not going to invoke law precisely because they don't want the constraints that the hardening of law may impose on them through reputational factors and whatnot. So I think sort of consider that possibility, that that's the main reason why you don't hear it, because those who are leveling the accusations don't really want it and don't want it to have those effects. Most of the paper is about accusations by states, okay? But what about accusations by non-state actors? Okay? You do allude to that. You draw the analogy to human rights. Human rights groups are often engaged in leveling accusations. They're big players in putting pressure on states to comply with their human rights obligations. The question is, does it apply in the same way in the cyber realm? Okay. And then in answering that question, think both about non-governmental organizations, but also think about the private sector. So what's the impact of Microsoft publicly leveling an accusation, or some other commercial actor, in terms of both pressuring compliance or having this constitutive effect? Finally, a point that you didn't develop too much in the discussion, but is in the paper, is the relationship between the accuser and the community within which the norm is situated, or the audience you're trying to influence. And what immediately occurred to me is, well, what is the dominant community here? Marina was talking yesterday. I asked her the question. You've got a group of so-called like-minded states, and I guess you've got a group of so-called, or what I would call unlike-minded states, and then you've got a bunch of states that, you don't know which way they're going to go. And it's not obvious that the like-minded states are the dominant community. It's not obvious that if you're going to make an accusation, you're going to be sort of drawing states into the normative framework that the like-minded, the U.S. and its allies, are trying to promote, but rather a normative framework that is coming from Russia and China and whatnot. And so thinking about what the community is here is important in trying to understand what the impact of an accusation may be. Okay? And maybe just to highlight another point here related to that, you give the example, well, if the UK levels an accusation versus North Korea leveling an accusation, who's going to be more credible? Well, UK, you assume, is going to be more credible, and I think that's probably right. But what if it's US versus China? In the eyes of the community that you're trying to influence, is the US a more credible accuser, or is China the more credible accuser? And, to further complicate, or to sort of add some poignancy to this, it's ironic that the President of the United States himself is suspicious of the accusations being leveled by his own intelligence community. So, who's credible and who's not credible within which community is an important issue, and that's obviously an important issue for intergovernmental debates. Okay? And then have I got a second left, Tony? One final point. And this is more about the recommendations and moving forward. I think it would be worth considering whether producing guiding principles, codes of conduct, declarations, something less than hard law, would that be constructive? You would think yes, if what you're trying to do is build norms. But on the other hand, it's possible it would be counterproductive. Because you might agree on a set of guiding principles that in a sense codify the lowest common denominator. It might be better just to do this more through a customary process. You level the accusation, you push for the development of a norm, you do it incrementally as opposed to sitting around a table and trying to agree on something. So, I lean towards the view that it would be worth producing these guiding principles or these declarations or these codes. But I'm not sure. You could argue the opposite. So I think it'd be worth thinking about that in the context of the paper.
Good. I want to give you 5 minutes to respond to Ian, if you want.
If you want to go first, that would be great, because I'm still thinking.
Then I'll open it up.
Sure, I'll jump in.
Start lining up.
As accused, we will plead guilty on the bait and switch. I think we were like, well, compliance is really interesting, but this naming and shaming thing is something that we definitely, that was the motivating factor. And again, I think there's actually a political piece from like April where, the Trump administration, particularly DHS and others, are like, this is our policy. This is what the U.S. government's, we talked earlier about what are the consequences, what are we doing? This is one of the big tools in the toolkit that at least the like-minded states now are thinking about using. And that led to, and then I think Jack Goldsmith on Lawfare has a couple of posts where he's like, this is horrible. It's not going to change anybody's behavior. And so if I were to kind of yes, I think you got the sentiment of where we were trying from was to say they might both be right. Like, this might be the policy, but it may be the expectation should not only be that every time you name, you have to shame, that we want to explore what else could be going on here, and that there may be value in this process, even if your Russia, your China, your North Korea are not stepping back from their activities. It may have other effects within the community. And I take your point about we should explore more the fact, what do we mean by the community or third-party communities? Because I think there are multiple, right? Every state has multiple identities. One is they're one of 192, 3 nation states. There are regional groupings, there are like-minded groupings, and so part of that is, in the strategic calculus, has got to be not just, what do I want to accuse somebody of, or how much do I want to expose it, but also what's the audience I'm looking for. And indeed, we talk a little bit about this in the paper. Clearly, a lot of these domestic indictments are as much for a domestic audience as they are for an international one. It's signaling, hey, the U.S. government, the law enforcement community is on top of this. We're not so incapable as people used to say 10 years ago that you couldn't identify these folks. We're identifying them now. Separate problem of getting them. So I do think that we could do a little bit more to talk about audience and community throughout. There was a lot more there, but we're not going to have time here. Let me see if Marty has anything to add.
Well, so two things I would just mention in response is we don't know what we don't know. So my suspicion is there's all kinds of private accusation processes going on that we just don't have access to. So that whole layer of this is a little, just for evidentiary reasons, is opaque to us. But so my assumption, it's logically there's a clear escalatory strategy, right? You make the accusation first in private, and then depending on the response you get, you ramp up or out strategically, depending on who you want to read. But the front end of that process, no clue. The other thing that I wanted to pick up on that you mentioned is thinking harder about who's the audience. And this relates back to, again, something that Marina was talking about yesterday. I don't know what the math ended up being. Was it 80 states, Marina, or whoever's not in the, yes, whatever that number turned out to be? Because I think a lot of these back and forths are a very insider club conversation. But if you're thinking longer term, and if you're thinking strategically, and if you're thinking through international organizations, one state, one vote, looking at you, United Nations kind of forums, those folks, you shouldn't write those people off strategically. All right, this could matter a lot, and I don't know how hard people are thinking about the diversity of audiences at play. I don't have a prescription for what's the best way to do this, but my suspicion is there's not a lot of thought going into it, or not as much as might be useful.
One quick moderator question. Is there any precedent that you can point to where an accusation has had a constitutive function that has led to a rule in any other area? Any precedent at all?
No, you mean in the sense that, yeah, I would say, I mean, so for a lot of these things.
In other fields, I mean.
Yeah. Do you want to go ahead?
No, you got one.
No, I'll let you go first.
No, I'm thinking. So I mean, certainly it's something we need to add to the paper, right? So I think that's unless you've got one off the top of your head.
I don't. I mean, that's why I said it's a very neat formulation, but I can't think of an example, so I wonder if it's really true.
Well, but you can, if you think about how large bodies, when I think back historically about how do large bodies of international law start to run, like how does genocide become a thing, right? There's actually a conversation about first defining what's the rule, that there is this thing called genocide, that it has certain content, certain contours. It's not just killing lots of people. It has specificity to it. And then there's a process whereby states talk about it, go back and forth. In that case, they rolled it forward to a treaty, but you wouldn't have to do that. When you think about expanding other kinds of human rights, LGBTQ rights, those, I'm now part of that. I now interpret equal rights to apply to this group of people, or to apply to women, for goodness sake, which it didn't used to. Those moves are a back and forth, right? That somebody has to stake a claim and say, no, the meaning of the rule is this now. And then there's a back and forth about that, that negotiates, do we agree, do we not agree?
Okay, why don't we Make sure you have a question, not a statement, and make it brief.
You're tough.
Yes, I am.
Write it down.
And give your name.
The research community that's working on the technical components of attribution, if they were to focus their efforts on one area or another of looking at tooling that leads to maybe an individual or machines or state level, based on what you believe the impact would be, as you kind of talked about, we want the impact, right? What do you think would be more impactful?
On what?
On the ability to change behavior.
What behavior? I mean, it all debate. It's function suited to task, so I need to know the task. I'm not a lawyer.
Oh,
I'm a parent. I'll confess to that.
If the research community is focused its efforts on improving technical attribution, as we established earlier, you can do that through, again, pieces of software knowledge. You can do that through machines. You can do that through people that were responsible for giving actions or people for taking operations, right? And each of those is going to require different sorts of data, different sorts of technical developments that are going to be researched, right? If in order of racking and stacking in terms of priority, which would have the greatest impact on changing behavior to drive compliance to norms.
To which norms? I mean, the question doesn't make sense in the abstract. I don't think there's. Is there a generalized answer to this?
No, but I mean, I'm going to give you an if, but. So
Okay.
if
That's better. Thank you. He's the lawyer.
If you're asking in terms of if the goal is to actually get your China to change its behavior, right? I think then I think this goes to somebody's comment earlier, is putting aside, I think tooling it up for the accuser's knowledge is one thing, and you may want to go full bore there. But I think one of the things we've been looking at, like the stigmatization literature, is that there's actually a point at which having too much detail and being too specific is counterproductive. That what it engenders actually a negative reaction, and you actually are less likely to get them to respond. Whereas like the irony about the OPM hack, for example, where you kind of have Clapper being like literally, hats off to them, and we're not saying that the Chinese did, and then the Chinese arrest like several hackers. They say, look, yes, it was coming from our territory, but they did it. Now, there's a lot of hypocrisy there and a lot of other things, but in the world of politics, that doesn't escalate any further because, China was a responsible state and it cleaned up its territory. And maybe that was the height of hypocrisy that time, but if that becomes a pattern, right, we're in a slightly different world. And so I do think that one of the things that's a little counterintuitive that we're trying to do with this paper, and this is where I think Tony's point is excellent, is we wrote this paper late and fast. We were really late. So we wrote it late and fast, and so we had the idea, but we haven't done the empirical. And I think it would be really interesting, and I'm actually fairly sure there's some examples, particularly I'm thinking in the environmental field, and I think there might be some IHL examples where you have some accusations that precede.
Ozone is one example.
There you go.
Yes.
Thank you.
Thank
See,
you.
You're answering your own question.
That if we're looking, that way, I just, yeah. So I don't know if that's responsive to your question, but it
No,
just,
but thanks.
Okay,
Yeah.
next up.
Hi, thank you so much for a great presentation. My name is Asaf Lubin. I'm a postdoctoral cybersecurity fellow here at Fletcher. I consider low-level cyber operation within a broader theater of information warfare, influence operations, and covert action. And if you consider it from that lens, then I have both a challenge to your premise and an additional function to your 5 functions. I'll start with the functions because it's easier. I think that sometimes we accuse to create misinformation. We accuse to create noise. We accuse to create confusion. That is what Trump is doing when he accuses, and Putin is doing when he accuses, and arguably that's what sometimes Trump is doing when he accuses. And so that is from a lenses of why do I accuse? I accuse just to take the scent off of me, and that is something to think about. And related to that, and that ties directly to the moderator's question about additional examples, I think that in the space of covert action, we've been accusing for centuries. So we've been accusing about political assassination since the dawn of time, and those accusations have not resulted in creating new law, quite the opposite. So I can always ask, who assassinated Skripal, or attempted to assassinate Skripal, or who killed the Iranian scientists in 2010 to 2012? And we have not created rules around assassination, or more broadly around covert action as a result of those accusations, and that would challenge the premise of one of your arguments.
yeah, so I guess I would say this super interesting case, but I don't see it as, our claim is, I don't see it as a challenge in the following sense, in that our claim is, correct me if I'm wrong, I think our claim is not that accusations always set this in motion, but our claim is that the back and forth of accusation and response is not socially, normatively, or legally neutral. Something happens, and that something might be nothing, right? I mean, it might be that you just end up in an endless circle, and for a variety of reasons, which in the case of like assassination, well, go ahead, sorry.
But it just might result in nothing in this space because of the similarities in low-level cyber operations and covert action. We'll get the same thing we got for assassination.
Yeah, or espionage.
Right.
You have
Espionage,
lots of
exactly.
You've had
Right, yeah.
accusations of espionage forever.
Exactly.
Right.
Precisely.
And what it actually does is it reifies the idea that every state prohibits espionage against itself and authorizes its own to go out, and that's what we've got. But I think part of what we're trying to identify is the potential for accusations to have a constitutive effect that in some ways may resuscitate accusations in cases where the accused doesn't care or is a rogue actor or ignores, which is not the same as to say that it will always have that constitutive effect. We just want to flag that if you want to take a glass half full, there still might be something that's possible to explain why you would still do this, even if you know that 100 accusations later, Russia will still be seeking to sow chaos and disinformation or what have you.
This is slightly tangential to the overall argument, but I think it's sufficiently connected to warrant asking. So there's an alternative actor who has a purpose with respect to the accusation, which is the accused. So the accused may benefit in various ways from the accusation in ways that are different from simply claiming the attack themselves. So this seems most obvious in the case of Russia, where Putin, it seems to me, clearly wants Russia to be attributed with the electoral hacking in the United States, with the Sergei Skripal poisoning in the United Kingdom. The way that these things were done seemed to be to facilitate the accusation. Go on, accuse me, come on. I don't want to say it myself, but I want the accusation. And so I wonder how that fits into the functional framework that you're laying out and the overall process you're describing. Is the idea that he has there, is it solely speaking to a domestic audience? Look how important we are. The United States, the United Kingdom are all in a tizzy about what we've done. They're obsessed with Russia, and the way to get them obsessed with that is to cause them to go through this accusation process? Or is it, I want them to sort of create a norm, but at the same time I want to indicate that the norm doesn't apply to me, or I'm willing to violate it as a way of indicating a certain willingness to go further than you are in the course of achieving my objectives, and so maybe deterring certain behaviors, saying when you interrupt what I'm trying to do in Ukraine, I'm going to interrupt what you're doing domestically. And so this is a parallel purpose because it operates at the same time as the accuser's purpose, but it's a different purpose and seems to be connected both to the development of the norms, but also the function that the accusation is playing.
I think those are useful observations. I think they actually make a lot of sense. I think we have a paper scope problem but I do think that part of the goal is who's going to control the narrative, and we have written this. And maybe we need to go back and think about, we've written this kind of from the say you're an accuser and you want your accusations to work, and we're kind of saying, well, what do you want them to work for? What's your purpose? And getting people to think more consciously, and then, okay, how are you going to construct it to do that? And look at the conditions, and you're right, we've had an accuser kind of mindset and vision, but you're absolutely right that you could flip it around and you could imagine an accused either trying to get an accusation started or having its own set of agendas and reactions when the accusation comes in that it may try and use to its advantage. I don't know that this paper can do both, but we probably should at least wave at it. Yeah, we need to acknowledge it, I think.
Yeah, I mean, the other way I would read that, as a social scientist, the way I would read that is, sort of what does Russia want? Probably this is, we don't agree with your premise. If you remember, there are the different ways you can respond. One is to say, I didn't do it, and one is, I didn't do it, and that wasn't the rule anyway. And I would guess without being a Russia expert of any kind, that this situation looks more like that they're not, this whole electoral interference thing, we've been messing around in Russian domestic politics willy-nilly for a long time. I don't think we have a lot of street cred with them on this issue, and so I think they would push back on the premise, the core normative claim behind our accusation, because they don't think we have a lot of clothes, if I had to guess. And I'm just not well enough informed to go very far on a limb for that.
Thanks very much for the paper. Really interesting stuff. Quick clarification and a question. Clarification on your 3 dimensions of accusation. Is it possible to have an accusation that is only exposure and condemnation without attribution? Duncan, you mentioned the Trisis case. That seems to be much more like standard cybersecurity industry practice of putting an event out there without any attribution at all. Does that still really count within the conceptual framework of accusation? The question is, in terms of your due diligence, you're suggesting that states could leave room for accused states to do their own due diligence, to go and find actors. My understanding of the direct accusation process is that direct accusations evolved from states trying to do this and it failing. Definitely in the case of Iran and of China, going to them with technical indicators, states like the UK and the US, and not getting any response, not giving them that room to do that due diligence and not getting any response led to them giving these like direct accusations rather than it being a sort of direct accusation, wait, we could do more, on the other way around. So the historical arc of accusation, I think, comes from giving room to due diligence towards direct accusations rather than the other way around.
Quickly identify yourself.
Sorry, I'm James Shires. I'm a cybersecurity research fellow at the Harvard Belfer Center just down the road. Thank you.
I don't know anything about due diligence.
So on the due diligence, I do, my thought is that, well, first of all, to your first question, I do think, at least theoretically, and this is the question of do we have actual cases, that certainly you could have an accusation that if Triton or Trisis were put forward by the United States, were to make a public statement and say, we think somebody out there has done this horrible thing, and join with us other states, won't you, in agreeing and condemning it, and can we all agree that we'll do a treaty, you know, it'll be that Geneva Convention on Cyber, we'll do a treaty to say that safety equipment vulnerabilities and compromises are off limits. And you could see it play out that way. So I do think it fits under our umbrella, but I do think that you're right, that a lot of it overlaps, and I think maybe cybersecurity companies haven't realized that they're making accusations, right? And that, you know, and when you think about the functions, like we do note that, like, if you're a cybersecurity company, one of the functions of these accusations is you're trying to make money and you're trying to raise your profile. I mean, Mandiant got a lot of mileage out of APT1. Dimitri and others at CrowdStrike have, you know, those accusations have a financial or enumerative function, and we have a footnote on that. But so I do think we have to look at that back and forth play. So, you know, on the due diligence, I would unpack it a little differently, because what you're describing to me was there was a lot of private back and forth with the technical indicators, and there wasn't the exposure. And I'm thinking about when you're going full exposure, you're going to be really public. I think what we're just trying to flag is that there's some trade-offs, and that being really specific sometimes can work in certain conditions if you have leverage over that actor and they value the community and they want to, you know, appear compliant and have reputations in good standing. You know, for whatever reason, Iran's not that actor, in which case it's not a perfect solution, but giving them the room to pretend that it wasn't them and then to adjust their behavior, which is what you really want. I mean, maybe you don't actually want them to admit that what they did is wrong. You just want them to stop. That might work if you use a due diligence model. And so it goes back to Marty's point is, you know, who's the audience and what do you actually want them to do? And maybe you want both, in which case you're right. I think due diligence may not get you there because it allows this hypocrisy of the Chinese saying, well, we took care of that OPM hacking problem for you. You know, we're really happy to have controlled our cyberspace and exercised our sovereignty in such a powerful way. I mean, you know, you can half empty, half full glass on that one.
Well, I think our time is up, and we have no more questions. So thank you for a wonderful panel, and thank you, audience. For wonderful questions.
We got a lot of great comments.
That was excellent.
Yes, and thank you for giving us the these
yeah,
accusations
yeah,
of you, the United States, are causing this in our territory.
Yeah.
And